cooperating.
I didn't.
want to stay there, you can move closer if you wish. But we're going to begin. All right. So this morning, it's my pleasure, honor to introduce you, Your Honor, to our favorite judge, right? Cymonie. But not only that, but a very active member of this parish and alumni of the school. We have a lot of alumni. I'm finding out little by little. I'm finding all the alum connections for the school here. And now on the board, on the school board, right?
Yeah, board of trustees.
Yes. So we welcome you. We give you thanks for doing this, and we ask God's blessing to be upon you as you present. Amen.
Thank you. Good morning, everyone. Good morning. This was probably the most daunting presentation I've ever had as it's to my family. So, my family is probably the hardest on me, and hopefully you won't be too. I call this a judge's perspective on the Episcopal Baptismal Covenant and striving for justice, peace, and respecting dignity. The Baptismal Covenant that we're going to be talking about today is, will you strive for justice and peace among all people and respect the dignity of every human being? We always respond, I will, with God's help. As a judge, a corollary to that covenant are prayer from the Book of Common Prayer, as well as a verse from the Book of Micah. On page 821 of the Book of Common Prayer, and every morning before I go out, I'm in chambers. I come in early in the morning to prepare, but also to have my own little quiet time to make sure that I am doing what God wants me to do. So when I'm in chambers and before I go out on the bench, I say this prayer and recite this verse. It's on page 821 of the Book of Common Prayer, and it's for prayer 21 for courts of justice. Almighty God, who sittest in the throne judging right, we humbly beseech thee to bless the courts of justice and the magistrates in this land, and to give unto us the spirit of wisdom and understanding, that we may discern the truth and impartially administer the law in fear of thee alone, through him who shall become our judge, thy Son, our Savior, Jesus Christ. Amen. Amen. While I'm putting on my robe, I say this. He has shown to you, O man, what is good, and what the Lord does require of you, but to do justice, to love mercy, and walk humbly with our God. That's my prayer each day. I don't know necessarily if I fulfill it each day, but I try to strive for it at least. So this is going to be an interactive discussion, and I want you to think about this as I go through my presentation. As I was told by Emily Nell, a rule follower, she said, you have 15 minutes to talk, and then the rest is interactive. So I'm going to use my 15 minutes now, but while we're doing that 15 minutes, I want you to think about this question. What does that baptismal covenant mean to you? So we'll dive into the topic. As a judge, there are realities and disadvantages, I guess, with regard to trying to strive for justice and peace. There's challenges to it. And it's an active word, it's striving. So it's constant. Every day is a new day to strive for justice and peace and the dignity among all human beings. And it's an intersection for me between my faith and my profession. So let's unpack the covenant. As I said, the covenant says we're to strive. That means we're not to sit idly by. Each of us must, strive, work hard to work towards justice, peace, and dignity of all human beings. And it applies to all of us. Even though I'm talking about judges and the law, it applies to each of us. Even in the judicial context, it's trying to ask you to also strive for justice and peace. And you are part of our judicial system. I'll talk about that a little later, but when you get your jury summons, you become part of the process, and you are judges. And so you are also striving for justice and striving toward the baptismal covenant. So I want you to kind of understand how my day is. I'm now in felony, which means I deal with defendants that are accused of the most heinous crimes. And my morning docket is organized chaos. There are probably 60 on a good day, maybe 90. I think tomorrow I'll have 60 cases, 60 pleas on my docket. There's in custody defendants that are sitting in what would be the jury box. There's out of custody defendants sitting in the gallery, which is where the audience generally sits. There's the attorneys, state attorneys, public defenders, maybe private defense attorneys sitting at the table in front of me. And then there's a case in the well, and they're all talking. The defendants are talking in the box to their attorneys, maybe talking about a plea or what's going on in the case. The out of custodies are in the well, and they're probably talking to their attorneys about whatever they're talking about. Sometimes they're just talking about the weather, and I have to tell them to please be quiet. But it's just organized chaos, and I'm trying to focus, as is the parties that are standing in the well, focus on the case in front of us. My deputy is there; he's trying to get everybody to quiet down because there's so many in custodies. There's likely corrections officers to make sure that none of them do anything wrong. There's clerks sitting there. It's just organized chaos. And in the midst of that chaos, I'm supposed to administer justice. That requires a lot of patience. It requires a lot of prayer. So I have my group here that pray for me daily. And my responsibility is to ensure that the person in the well is getting justice, that I'm listening to what their case is about, that I'm absorbing it, applying it to the law, and making sure I'm making the appropriate decision. So it's constant work. It's just constant striving to adhere to that baptismal covenant. So justice, how do you pursue justice as a judge and peace in the courtroom? It requires empathy. It requires understanding where that person is coming from. I remember a case in which the defendant, he was in custody, and I don't think he knew how to say a sentence without using the F word. Like everything he was saying. And as a judge, I have the power to hold somebody in contempt. That is a contemptible act. You have to have decorum in the courtroom. But I understood that that's just the normal part of his lexicon. So, could I have held him in contempt? Of course. But should I have held him in contempt? And that's the issue. And as a judge, it's a constant balancing of what you can do and what you should do.
Pick your battles.
Exactly. And so for that gentleman, I cautioned him, this is a courtroom. This is not the streets. So please make sure that you speak with, the appropriate language, and we cannot be using F words in the middle of court. And you could see that he was trying, because I approached him not in a Judge Rowe context. I approached him with, I understand where you're coming from. These are formal proceedings. We have to act with decorum. We have to act with professionalism. And he tried. And so I never held him in contempt, although I could have held him in contempt. And I think that's another aspect of striving for justice and peace, kind of, as it's Nancy said, picking our battles. That's not the hill that I needed to die on as it relates to contempt. When I just finished Judicial College, all new judges, whether appointed or elected, have to go to what's called Judicial College. And I remember years ago, Mom and I went, and I was in awe of this Judicial College, and now I'm faculty. And one of the things we tell the new judges is to pick your battles. We have a course on contempt, and back 9 years ago now, I was given a card with 3 dots. Those are the 3 times you should only hold somebody in your entire career in contempt 3 times. So you really need to. It's not a rule, but it's the concept is you don't have to hold everybody in contempt all the time. And so, pardon me?
It's not a power issue.
It's not a power issue, and I think most of us as judges recognize that we have the power to do X, but it's not necessarily always necessary to do X, and you have to just use your wisdom and judgment, which is why that prayer is so profound for me, to give me the wisdom and discernment to figure out what I need to do on that particular day for that particular case at that particular time. It also involved, one of my roles as a felony judge is to sentence. And I think of all the aspects of being a felony judge, sentencing is probably for me the hardest. Because again, it's trying to find that punishment, which is what Florida is all about, but in context with everything else. There's defendant has a background, the victim's family have a background. They have lost someone or someone has been a victim of a heinous crime. And I have to absorb all of that. And I have 3 examples that I can give to you as to how I try to strive for justice, but also being mindful of our baptismal covenant. I'm a rule follower, as I said, and I have to prepare because I'm an introvert by nature. So in order for me to overcome my introvert nature, I prepare. And sometimes I over prepare. In fact, at Judicial College, one of my colleagues is like, Cymonie, don't overthink it. Because that's kind of what I do. So I had a sentence in which it was a manslaughter case where a young man was in the car with his best friend, like they're brothers, without biologically being brothers. And the police, he was committing some traffic offense. And instead of stopping for the traffic offense, he sped. And he's young and not experienced as a driver, and they ran into a tree. And he killed his friend. And he was severely injured as well. So fast forward, we're at plea. He's going to accept a plea. And they did what's called an open plea, which is they'll plead to the crime, but they're deferring to the court as to the sentence. So it's all on me to decide how to address this. And in the state of Florida, we have a law called Marcy's Law, which means all victims and victims' families have a right to participate in the criminal procedure and have a right to be heard at the sentencing. So I was prepared, and it was a heinous crime. The child deserves some type of sentence, prison sentence, and I was expecting to do that. Defendant's family spoke. Mom spoke for the young man that passed away, and judges aren't supposed to cry. And she was telling me her story about how these 2 young men grew up together. They were brothers. The defendant, who her son was in her home, and she's like, my son, again, would not want me to send him to prison. So I'm asking you, Judge, please do not sentence him to prison. It's not going to bring my son back. Nothing's going to bring my son back. And I want you to sentence him to whatever you want without prison. And I did what she asked. Because I had the discretion to do that. He could have been a youthful offender, so I had parameters. Usually the sentencing guidelines are very strict, and you can only set them within a window. But in this particular instance, I could not sentence him to prison. I honored her request because she came to me in tears telling me that this is not what she wants, even though this young man took her son. In my mind, I was striving for justice, and I hope that I did what was supposed to be done. I felt comfortable with it. That's one of the other things that I try to do, is make sure that I can feel comfortable with whatever the decision is, that I can go back home, go to bed, go to sleep, come to church, and feel comfortable with my decision. Then there's another case. A lot of times I don't even know many of these cases high profile until I'm with Daughters of the King, and my Daughters of the King sisters will text me, Cymonie, I'm praying for you. Okay, I know you are, but it's based on some case that came out, and this case came out in the paper, and it was another young man, driving again erratically and killed a 77-year-old man. And again, it was a plea to the court. It was pretty contentious. I thought at one point the young man was going to go to trial because he kept seeking experts and things like that. Again, the family came into court and agreed that he also should not have any jail time. The one thing that they wanted was that I would adjudicate him as a felon, which if you're adjudicated as a felon, it has a lot of consequences. You can't vote. You can't own or possess firearms. You have that felony conviction. If you go to rent or buy a house, you have to put that you're a felon. It lasts with you your entire life. That's all they wanted. The young man, this was his very first crime, stupid as it was. Again, he could have not been adjudicated. I could have put him on probation like I did the other case. The victim's family wanted the adjudication, and that's what happened. The young man was adjudicated as a felon. Then the third example that I can give you is an instance in which sometimes you have to tell the victim's family that what they want may not necessarily be in their best interest. And this was started out as a first-degree murder case. Incident that happened at 3:00 in the morning. My brother always says nothing good happens after midnight. Apparently, these two individuals knew each other and had issues, and the defendant, not knowing that he killed him, stabbed him, and they stabbed him mortally, and the decedent then ran into a tree and died. The defendant goes home and again doesn't realize that he killed anybody. Of course, was coming to arrest him, so he's arrested for first-degree murder, and he's been in jail probably 6 years before I even got to the division. He'd been in jail a while, and he pled finally to he and the state attorneys agreed to, he filed a stand your ground motion, which is in Florida, it's like the castle doctrine. If you are where you are, you have a right to be, your home generally, but sometimes it can be in the public, and somebody approaches you with deadly force, you have a right to defend yourself. Even if it's deadly force, you can meet deadly force with deadly force. So that's what the defendant was pleading here. That came to me based on the facts. That was denied. So now we're getting ready to for trial, and he and the state attorney made an agreement for second degree, which would mean that he would not go to jail for life, and the sentence was 17. So that's what they agreed to, the state attorney and the public defender, the defender's office. And the mom was at the sentencing by Zoom, and she was very upset. She's like, I'm never going to see my son again. I want him to go to jail for life. I want you, judge, to sentence him. Like, ma'am, there is a stand your ground. And I can give you another example as to how stand your ground. I thought there was stand your ground, and the jury didn't think there was stand your ground. So I explained to her that just because he lost the stand your ground, a jury of his peers could find him not guilty and he could walk. So, 17 years may be better than having a jury decide the case and then he walks. She agreed, and the sentence went forward, and the gentleman is spending the next 17 years in jail, in prison. So these are just aspects of how I try to strive for justice and adhere to that baptismal covenant by making sure that I respect the dignity of all individuals. I respected Mom's hurt and pain, justifiably so. She lost her son. To her point, she will never see her son again. The defendant will be able to, live a life, although he would be in prison. So it's a balancing act. It's not easy. It's a lot of pressure. But having this body here in this space, praying for me on a daily basis, truly gives me the peace and gives me the strength to strive for and continue that walk where I am balancing, making sure I am adhering to the law, which is my constitutional responsibility to adhere to the law, whether I like it or not, but also do so in a way where I am listening to both sides and making sure that I apply the law to the facts in each individual case. Leads me to how that applies to you. Remember, I said I would come back to that question. Well, you all can strive for justice and justice as well by serving on the jury. And this is my plug. Part of my canons is to go out and speak about the law, to get folks to appreciate the law. I'm the judge of the law. Jurors are the judge of the facts. And we need folks to want to be on the jury. to hear the facts, to apply the facts and decide what the facts are, decide what the facts mean, and determine whether or not the state has met their burden, and render a verdict of guilty or not guilty. And so I ask you to join me in adhering to that baptismal covenant, by welcoming and not being
Answering
sad,
that summons.
answering that summons, answering that call to jury service. So I think that's my 15 minutes.
You can have more if you want it. I may have more. And the other 2 cents you want to add.
Can you serve on a jury without being summoned? Unfortunately, you cannot. And just to give you sort of a preview, some of the attorneys, I remember when I was practicing, if a juror was excited about serving, we'd be like, I don't know. So there needs to be a little bit of a balance between, yes, I want to serve, and no, I don't. I remember once I had a juror cry when we told her that she was gonna serve on the jury. Like, she literally cried from the well to the court, and she goes, ma'am, I promise you, you're going to enjoy it. You're going to find that this is the best service you've ever done. And afterward, I think she became the foreperson, and I did my first selfie with her. So a lot of people have a lot of preconceived notions about jury service, probably based on what you see on the web, on the internet, or just hearing from other people. But I've been doing this now. I've been blessed to be a judge going into my 9th year. And I've, with the exception of 18 months, I've always done jury service. I have not had a jury. And I give out all of the jurors that appear that serve in my court a questionnaire at the end. Every questionnaire says it's the best service they've ever had. They do it again. They tell their friends. So I don't know why there's this notion about jury service being daunting and a waste of time. It is truly the best service. And that's just based on other jurors tell me.
Could be fear of inconvenience, like how long the trial is going to last.
It is, and even for the long trials, for a period of time, I did tobacco litigation, which those trials were probably 3 weeks in length. And even for those, I mean, obviously, if you're a sole breadwinner and you don't get paid if you don't go to work, things of that nature, I can get why a 3-week trial may not be for you. But there in felony, it's interesting. In civil, it's 3 weeks for a tobacco case. I did a 1st-degree murder case in 4 days. Jurors spent 5 minutes rendering a verdict. I don't understand how all of that works. That's their system. But, there is a place for you. And I ask that everybody consider serving on a jury if you ever get your summons.
I have a question for everybody. Nancy was on a jury. Guess what she was?
Foreperson. Why would I be- Everybody else.
It's like a flower.
How is that?
I think I have been foreperson every time I've served, and you vote the minute you walk through the door, and I think they don't even know me. How can they tell?
That's another fascinating, there's a psychology thing about jury service. So, depending on the panel, I've had jurors 300 in the panel. I've had 50, I guess, in the panel. And each of you are kind of looking at each other like, who are you? Who are you? And then by the time you actually render your verdict, you're exchanging telephone numbers, you're planning lunch. It's fascinating to see the transition from being total strangers to ultimately becoming best friends once the verdict comes in. Or even if you're not selected, for example, the alternates are like, okay, tell me what the verdict is. I'll give you my phone number. It's just very fascinating.
I read recently that they're reviewing the cases, and I'm not sure what state it was in or if it was across the country, of people who had been abused for a long period of time, and they wound up killing or badly injuring the person, the abuser.
Abuser?
So where is that being done, and how are they going to go about it? Apparently their thinking is that the length of the prison term maybe should be shortened, or it should be reviewed in a different light because of the
psychological situation that these people find themselves in, and what spurs them to take action of their own because there's no other way out.
Are you saying that that's in Florida?
I'm not sure
I
where
think
it
it's
was.
the Menendez case that's brought it.
I have not heard that in Florida. So I don't know, and I don't think that that is something that is being considered in Florida. I can say, despite what you feel about many of the defendants, they all have a story. I remember I was in juvenile before I was rotated into felony. And in juvenile, in our circuit, which is only 5 in the state that do both delinquency and dependency. So a judge in juvenile in our circuit does both. Dependency, which are children who are victims of abuse, neglect, or abandonment. And then delinquency, children that are accused of crimes. And we do them both in our circuit. Most sadly of the defendants started out in the juvenile system, either a victim of abuse, neglect, or abandonment, then likely that they become a delinquent themselves because something happened and they act out. And then sentence a young man to 42 months in jail. He started with me at 14 in juvenile, and he liked that criminal lifestyle. I don't know why. And his mom was at her wit's end, and she's like, "Judge, please do something. You know, there's limitations. I can't, as much as you think I can do, I really don't have a whole lot of power. There's not much I could do." I tried to connect with the young man. I made the connection because every time he saw me, he'd be like this, and he'd be very embarrassed because he had to come back in front of me, but he couldn't just get away from him. And I said at one point, if you don't stop, you're going to go into the felony division, and there's nothing I can do except sentence you to prison. And sure enough, 17, they direct filed him, committed a bunch of burglaries with his crew. And he just happened that I rotated to felony and he rotated to felony.
Good to see you, Judge.
That's exactly what he said. Well, he didn't say good to see me. He was so like shamed by it. But, you know, I say that to say that every defendant has a story. And I'm not saying that you tweak the sentence because of it, because they have committed a heinous crime. But if we did that for them, then there likely potentially has to be something for the other folks that are abused, neglected, or abandoned. I don't know, but I just know that in the state of Florida, that's not, that has not come up. And there's a self-defense. So for those that are, again, another high-profile case that I had, a lady was accused of killing her husband. She shot him 9 times, 3 in the front, 6 in the back. She asserted battered spouse syndrome. That was her defense, and they acquitted her. So there is an avenue by which those individuals that are victims of abuse can have a self-defense if it applies. And in that case, it applied, and the jury read their verdict, and she was acquitted of shooting her husband.
So it wasn't just situational, it was also psychological syndrome, better, yes.
A lot of data.
You have to assert that as a defense. The state is entitled to have their experts. Obviously, to assert the defense, the defendant has their own experts, and then the jury makes the determination as to which expert they believe based on all of the facts and circumstances of the case. And they will decide whether or not self-defense applies or not.
I think that the word that you accented in the beginning is striving, right? That we're called to, not just be aware of, just look on or, but to do some, work towards it. Because we're all called to make judgments every day, not as critical as the judge is a thing in a felony court, but we're all in the course of even walking down the aisle in a grocery store. We're judging, we move this way for this person coming this way, and taking those same kind of things into into our everyday life, right? Judging requires us to, I think your other word was empathy, to recognize what's in the other person that we're talking to or about or with. So, thanks. I think those are important words, I think.
And talks about empathy. I see some heinous stuff. The other hard cases are the ones where there's a sexual battery and a minor. And to prove that up, generally, the minor is interviewed by what's called the CPT, Child Protection Team. And we get to hear, judge and the jury hears that, assuming the evidentiary foundation is laid for the jury to hear it, but certainly the judge hears it. And those stick with you. And you see this person in front of you accused of doing unspeakable acts, and I still treat them with dignity and respect because everybody is entitled to dignity and respect. So empathy plays a role regardless of whether the person has committed a crime where self-defense applies and they're acquitted, or there's a crime where a defendant has been accused of doing unspeakable acts to a foreigner. They treat them all, call them Mr. or Ms. or whatever appellation they want me to call them, and listen to them. And if the trial results in a conviction, sentence them to life imprisonment and wish them well there too, because everybody is entitled to.
How do you, as a judge, as a Christian, reconcile that?
I do it. That's a question actually the governor's asked when I was being interviewed, and my answer is the law is the law. My personal feelings cannot, whether I believe in it or not, and I choose not to say what side of the fence I am because I'm being recorded. The law is the law, and my responsibility is to apply the law. There's a jury instruction that jurors hear. You have to apply the law whether you like it or not, because that's the law. And that's how I approach the death penalty. Whether I believe in it or don't believe in it, the law is the law. And in most instances where the death penalty applies, the acts were pretty heinous.
In Florida, is there for the death penalty, does it have to be a unanimous decision or is it a majority?
It's changed. There was a period of time where to impose death, it had to be unanimous. Recently, it's been changed to, I would say, a supermajority. It has to be at least 8 jurors of a 12-person panel. But 8 have to vote for that, for the death penalty.
Why was it changed? The Parkland shooting, wasn't it?
Pardon me?
The Parkland shooting was one of those cases where they were debating whether.
No, Parkland shooting had nothing, Parkland shooting, how that happened was the defendant pled
Okay.
and pled with the intention that the death penalty would be taken off the table. And then it wasn't. The judge decided that the death penalty issue would be decided by the jury, and the jury rendered their decision.
Why was that changed from a unanimous to a supermajority?
Try to remember if it was legislative or Supreme Court, but
I think it was
I-
legislative.
the higher court decided that it was that the change happened. I kind of don't remember.
I just wonder why wouldn't it be in a verdict? Doesn't it have to be unanimous?
Verdicts have to be unanimous. In this instance, it has been decided that death penalty does not have to be. The jury, it's a two.
So the guilty
Parties
has
is
to be unanimous.
Correct. There's different phases to a death penalty case. There's the guilt phase. Did the defendant commit the crime? Or did the state prove the defendant committed the crime? And then
What are
that
the
has to be
consequences of that?
that has to be unanimous. And then the second part is, does this defendant, should the jury sentence this defendant to death or life in prison?
What percentage of the defendants represented by the public defender's office. Okay.
Most of the cases that are in front of me are with public defenders.
Yeah, that's my favorite.
And I have to say, my partner that I teach with, he says it this way, and I like it. When we're telling a defendant that we're appointing the public defender, we're appointing the largest criminal defense law firm in Palm Beach County. And I like that because it is. And my experience with the public defender's office, they are really good. There are some defense attorneys in my division where, God forbid, if I were ever accused of a crime, I would hope that I would be indigent enough to be able to get out and defend me.
The best decision.
And we need no longer.
Did y'all hear that?
Say it again.
Appointing Cymonie was the best decision Rick Scott ever made.
Yes.
We agree.
Violence.
Probably the only good stuff. I try to move through my world with the belief that dignity begets dignity and that offering dignity returns dignity. I think there are a lot of people, sadly, that move through our world that believe they deserve to be treated in a dignified manner, but they don't necessarily have to return it. And I find my joy, my little daily joy, moving through my neighborhood on a walk or on my bicycle and passing the nameless, faceless people and saying, "Good morning, gentlemen," and just see their spine straighten. Someone just treated me with dignity, called me gentleman in my, menial service that I'm offering. It's interesting you say that, because again, I try to treat all defendants with the respect that they're entitled, regardless of the crime that they are accused of. And sometimes they think that we were friends. Now they're writing me letters. Yes.
Next time.
Pardon me?
Hope I get you next time.
Can you please help me out with this?
Do y'all do a lottery for judges?
What do you mean?
How do they determine what judge is assigned to what
Case.
case?
So, that's a two-part question. When you become a judge, there's a chief judge in every circuit. The chief judge decides what division you are in. And that decision differs depending on the circuit. In the 15th circuit, we have a mandatory rotation. So, every judge is asked to stay in a division at least 2 years. And every judge is asked to leave a division after 6, or the chief will help you.
How many divisions are there? How many?
There's probate. Well, for the assignments, it's more than that. But as to your question, there's probate, there's family, there's juvenile, there's criminal, there's civil. On the circuit level. So there's that. So the chief will assign you to a division. Then as it relates to the cases in your division, the clerk randomly assigns those cases. So in a civil context, if there's 7 judges, case 1, 2, 3, 4, 5, 6, 7 goes to the 7 judges, and then we start all over again. Same with criminal. Criminal is a little different in the sense that if a defendant sadly commits multiple crimes and have multiple cases, we try to have that judge have all of those cases to make sure that all of the cases are addressed either at the same time, or the state attorney can make the determination as to, I want to try this case. These other cases will, what we call, track those cases and the like. And as another corollary, if a defendant has cohorts, those defendants will also be, so if there's one case where it's a burglary and there's 5 defendants that are alleged to have committed the burglary, the judge will get all 5 cases, even though it's randomly assigned. And we as a division will figure that out. Judge Smith, making up the name, will say, I have defendant B, but you have defendant A, so that all of the cases. Oh, my husband's asking.
represent a very diverse community? Is the courtroom becoming more diverse or less
On the bench diversity or,
in the courtroom? Lawyers, judges.
well, as for lawyers, women are outnumbering the men. Both in law school and in the courtroom. So there's that. I would say yes. I would say it has grown in seeing different people from different walks of life come into court as professionals, not as.
How about defendants? Is there a skew of population? What is it that you're seeing?
There is a commission called the Criminal Justice Commission that is in our circuit, and they have met with the felony judges to address what they are asserting is the disparity and how to address it.
In terms of arrests and,
Yeah.
and
Well, coming to court, but to your point, the judges only see the cases that are filed. We're not the ones arresting folks, so they only come to court if there's been an arrest or an accusation. So it's a study, and I know that there's work to be done, but I think identifying whatever the concern is at its core is what's important, because we don't pick the cases. That's
how
one
is
of
it
the-
determined that somebody, how is it determined that a situation comes before you?
Well, law enforcement generally is the first sign, so they will make a determination as to whether arrest is necessary. Then it goes to the state attorney's office. The state attorney is the one of the notions that you all should walk away with is the state attorney is one that has most, if not all the power. They're the ones that decide whether to charge the crime, the level of crime to be charged, whether they're going to plead, or whether they want to take it to trial. They really are the ones that have much of the power. So at the end of the day, they're the ones that decide whether or not they're going to file a case. And that's an elected position. The state attorney is an elected. We have a new state attorney.
Yeah.
And we have a new public defender.
But there are attorneys within the state attorney's office, aren't there?
Right, there's a whole level of attorney.
Are there civil service people within that department, or
They're all
are they
civil
all
servants.
appointed?
No, the public defender, nobody's appointed. The state attorney's office is an elected position. The state attorney then hires the assistant state attorneys within.
So they serve at the pleasure of the state attorney.
Yes. Yes.
How important is the role of an advocate? I guess it's mostly in juvenile setting. I know session one time when they talked about becoming an advocate and how important that is. Is that still the case?
It is, and
Is that guardian
What-
ad litem?
it is. One of my ideas, to hopefully speak to about bringing some folks from the juvenile, here for maybe a panel presentation, maybe join with another church. But to your point, yes, there's guardian ad litem. In a juvenile context, dependency mostly, because that's where the guardian ad litem come into play. There are so many participants in that process. The guardian ad litem advocates for the best interest of the child. So sometimes the best interest of the child is the guardian ad litem sees it, it's not what the child wants. So then there's an attorney ad litem that would represent the interests of the child. So there are two. And yes, there's a huge need for guardian ad litems. There's a huge need for attorneys to represent parents and dependency actions because they're paid through the state. And hopefully answer.
Is the guardian ad litem a volunteer?
It is a volunteer position.
So guardians ad litem in the state of Florida don't have to be attorneys.
No. In fact, I think it's encouraged.
In New York, in New York, all the guardians ad litem that are attorney for attorney.
No, in the state of Florida, you do not have to be attorneys. You have to go through some training. But no, do not have to.
But there is an attorney ad litem also.
Correct. There can be an attorney ad litem appointed to a juvenile in certain contexts, and that would be an attorney. Because the guardian ad litem is the person that meets day to day with the child. Then there's the attorney for the guardian ad litem that speaks to them concerning.
However, don't the guardians actually speak in court?
They
at
do.
times?
They do. But they don't file legal pleadings. The attorney for the guardian.
Is it an attorney for the guardian ad litem or for the child?
The attorneys for the guardian ad litem.
So they're representing
The
the
guardian.
guardian, so that the guardian ad litem has some legal
Yes,
representation, support.
yes, they are parties to a dependency action.
First of all, thank you for sharing all of that with us. I want to take you back a minute to your mention of empathy and your striving. While I don't have to sit in judgment every day, I find myself, and while I think Micah has always been a touchstone of my moral compass, I find myself every day seeing somebody or hearing somebody and making a judgment. And for me, I find myself constantly saying, oh my gosh, I've got to pull myself back. Sometimes quicker, sometimes later. And then in a very practical sense, much of my family is Jewish. And you can imagine what their reactions are to anybody from Gaza. It's one thing to think about the folks who committed those atrocities on the 7th. But so much of the Jewish community has come to believe that anybody in Gaza, all those Palestinians, want them eradicated, moved out. And it's hard, it's very hard to push the notion of empathy, trying to understand where maybe a Palestinian mom is.
Yeah.
In all of that. So I think it's what's going on in the program. It's also a reminder every day we've got this challenge.
The covenant does not just apply to legal system, it applies to all of us.
Statistically, yes, I read recently that women receive lighter sentences than men. That's looking at all the statistics. Why is that?
I don't know if that statistic is accurate.
For the same offense, or just because their offenses are not as heinous?
I
The
have not.
article didn't differentiate. It just said that overall women, and they gave some reasons, maybe because women tend to be mothers, they tend to be the heart of the family, a lot of the emotional kinds of things. But
I'd be interested to know a little deeper data myself.
But like the judge said, her feelings are not involved in this. You cannot involve your feelings when you're making, a decision as to someone's responsibility in a crime.
And in Florida, there are guidelines, so we pretty much have our guardrails with regard to sentencing to eliminate just what you articulated. So that's why I said I have not really seen it. There is an opportunity for some defendants, there's a statute that applies to request the court to not follow the guidelines and what's called downward depart. But those are very specific. It's not an easy hurdle to climb for a defendant. And in my tenure in felony, no female defendant has ever asked me to downward depart.
yeah, it
in the
wasn't
cases
Florida,
where
it was nationally, not.
Florida is somewhat unique and potentially maybe a unicorn with other states. I think somebody said the California case with Menendez. That's not how Florida laws work. We have pretty specific guidelines, and to deviate from those guidelines, there has to be something special for a judge to do. There's even a score sheet, which the state attorney prepares and the defense agrees to, where it has the history of the defendant and any crimes. And then it has what the minimum score is, which is what the minimum sentence a judge can impose. And, you know, you, between, it's either that or whatever the statute provides.
So how, if you've got a victim's family saying, oh, you know, we recognize that bringing back this is not going to bring back the child, you know, where does that all play in that score sheet?
The or you want me to go back to the example or just in general?
Well, whichever, you know.
So in the example, the youth did not, there was no motion for downward departure in that particular case. So the details of the case escape me right now, but it wasn't as though I downward departed. It wasn't the defendant filing a motion for me to downward depart. It was something where where I did not have to sentence the young adult to prison, or I could sentence the young adult to prison. I think your question is, when do I downward depart?
Well,
in the other
if you've got
instances?
a victim's family who is really adamant about something on the part of mercy, how does that play in this score sheet?
If it doesn't, it doesn't, unless there is a legal basis for the court to downward depart. In those instances, if the score sheet says the defendant scores 36 months, for example, and the victim's family says, I really don't want Mr. Smith to serve 36 months, judge, you know, please send, unless there's some legal basis, I cannot downward. But the youth was in a different situation.
By the same token, when the victim's family makes an impact statement, do you have the discretion to increase the amount of time that they serve?
Yes, because I can sentence them up to whatever the maximum sentence is. So the score sheet tells me what the lowest sentence I can impose, unless I want to downward depart, which I just told you. But I can sentence the person up to life or whatever the sentence guidelines impose.
So there's a maximum also.
Correct. For example, on, you know, on a sex battery against a minor, it's capital life. Life.
Really?
No parole. Yes, and in fact, they're changing, I think they have changed, well, I don't think it's come in front of me, where the state of Florida is seeking death penalty for sexual batteries against adults.
We'll check to the question, because I guess Will's watching online, Will Harmon,
Yeah.
and he asked, the difficulty when it comes to ballot time, and you're deciding to vote on judges, right? It's very difficult. And for those of us that, you know, don't know, don't know.
It is.
So he's asking, I guess his question is, you know, how do you know?
So I'm rotating off. It's been 6 long years but it's been the best years. On the Florida Bar Committee, it's called the Constitutional Judiciary Committee. And that committee has a website, so I encourage you to go on the Florida Bar website. All judges who are up for election can put all of their information in one central location for you to see the biography of the judge, you know, get to know the judge a little bit better. One of our canons is for us to go out into the community so you can get to know us. So I'd be here anyway, but I tend to go out and
Check that box.
I go out into the community to let people know kind of who I am and serve in other capacities. But there is a resource, which is the Florida Bar website, to find out about judges when they're up. There are other entities. I think the Florida League of Women Voters also does something. So there are other nonprofit entities that also participate in that process. But for a unfiltered, you know, nonpartisan place to look just to get the facts would be the Florida Bar website. And we are, our commission is seeking to improve that. knowing that it's very hard for the community to really know, do I vote for Judge Brown or Judge Smith?
Right. Yeah.
Get information.
Thank you.
On the ballot, that's probably one of the less check marks, that
It is.
people leave it blank because they don't know.
It is, and I'm part of the National Association of Women Judges. We have a campaign where we ask you not to leave that box unchecked because it's very important. The trial judges are really the ones on the front lines making decisions that impact your day-to-day lives. And so leaving that box unchecked means you're leaving that decision-making process to someone. Pardon me?
It's hard to get an informed voter. That's another
Right.
place they have to get informed.
Right, they do. And this is the one area where it's hardest to be informed. Judges, whether campaigning or on the bench, we can't advocate for ourselves. We are limited by our canons. Candidly, we don't really have a First Amendment right. So we have to be very mindful of the venues in which we speak.
If I remember correctly, the Supreme Court situation, like there were two people, I think, or two seats that were being voted on. And there's something like, they're being elected now, but they only go to like the end of the term. And then the governor decides, it was like the governor's going to decide one way or the other on the Supreme Court.
The governor always decides on the Supreme Court, but your question, as I take it, is two parts. One, every judge in the state of Florida has some voting component to their office. Trial judges, we have a true election process where somebody challenges the judge or the seat is open, they actually have to campaign, potentially with another opponent, with another person. In the appellate level, the governor always appoints the judge to that position. However, you as the voting public have an opportunity to determine whether to retain that
That's the
judge
thing.
at a particular period of time. And it's interesting, some folks didn't know what retain meant. Retain means to keep them. So you were voting whether to keep them. And that happens every 6 years, depending on when the judge was appointed. So if a judge was appointed in the middle of a term, let's say Judge Smith retired, every judge has a 6-year term, whether it's state court or appellate. If Judge Smith, who's been on the bench for 30 years, in fact, a judge in our district is getting ready to retire, if it's in the middle of her term, the governor would appoint somebody, and then at the next election cycle, that judge would be on the ballot for retention, meaning you all would decide, do we retain, keep that judge in that position or not? And for the retention, for the appellate judges, they have to meet, I believe it's 60% of the votes. So if there's 60% of the voting public do not vote to retain them, then they potentially, it's never happened in the state of Florida.
Yeah.
It's never happened. So it'll be interesting waters if this ever does happen. But if a judge does not get that magic number of votes, then the logic is that judge would be removed and then the governor would appoint somebody.
It was a retirement situation that I couldn't figure out. So this past election, one or two people had retired and previously, and two women had been appointed to hold that up to this point, and you were voting on whether or not to retain it.
That's exactly.
Now, are you going to be up for election?
Fortunately, I was very quiet. I had my election last year and nobody knew and nobody challenged me and I'm stuck with it for 6 more years. I won't talk about, like I
There's no,
said,
there's no
because if nobody opposes me. So I was up for what happens, it's called qualification period. If anyone saw me during that period, it's very stressful because we have to get our paperwork in a particular time. If it's not in for a particular time, we could lose our jobs. You know, Steve was part gassed up if the paperwork isn't in Tallahassee, we're going to fly to Tallahassee to make sure we can deliver the paperwork to the state to make sure it's on time once we lose our job. So that's the qualification period. You say, yes, I want to keep my job for the next 6 years. You fill out a lot of paperwork. You pay a fee. You pay a
qualifying fee.
Yes, it's a lot of money. You pay that and then you wait and you wait.
To see if somebody challenges. you.
Correct. And at 12 o'clock on April 26th, nobody challenged me. So at 12:01 on April 26th, you would not see me in the paper because nobody challenged me. But if somebody did challenge me, then
Then
you would. then
and
you
that
would-
other person would be there.
Correct.
Okay.
So should we?
Thank you.
Thank you.
Thank you very much. Excellent.
We're a small but powerful group.
You are.
I did my due diligence.